Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I'm your host, Attorney Elsa W. Smith, your Maryland estate planning attorney. And I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Through the guests and the educational content that we provide on this program, my hope is to provide you with glimpses of what an empowered woman is and the tools that she needs to win. Now, today's topic is debunking myths about estate planning. And just for those of you taking notes now or on the replay, I'm going to share about 10 of them today. And as I go through these, I want you to keep track of the myths and misconceptions, that you've believed. And then I also wanted you to think about why you believe them. And if you feel comfortable, you can share if any of these myths resonate with you. If you've believed them at some point in your life, you can put that in the chat. And, I understand that some of us may be a little embarrassed, quite frankly, to admit that we've believed one or more of these myths. This, I want you to know, is a no judgment space. It's a no judgment zone. More importantly, I want us to move from a lens of viewing things through shame for believing any one of these myths to one of evolution, right? What I mean is that once you've learned the truth about a certain issue, you've evolved, you're growing. Tony Robbins says that if we are not growing, we're dying. And each of these Women Winning Wednesdays episodes is a new opportunity for all of us to learn, to grow, and be more empowered. So let's get started. As I said, the topic today is debunking myths about estate planning. And the first one on the list is probably one that you guys are familiar with already, is estate planning is just for the wealthy. This myth comes from the focus of, a lot of estate planning attorneys and financial advisors on estate taxes, which may not be an issue this year until your estate surpasses just over 12 million. And that's an amount that, most of us would characterize as pretty well off, if not downright rich. So estate planning is so much more than that, though. It's about making sure that your finances are taken care of if you're incapacitated, and that the decisions about your health care are carried out in the way that you'd like, even if, especially if you're not able to verbalize them or vocalize them yourself. And estate planning is making sure that your children and other heirs are taken care of when you're no longer with us, and really mapping out a strategy for that. The second myth is, oh, I don't need to write a will because I can just tell people what I want. This is another myth of the oral will or a verbal will. Oral wills are essentially verbal wills. Be aware, however, that in Maryland, the state of Maryland does not recognize oral wills. A last will and testament needs to be in writing. It needs to be signed by the testator, that's you, and then witnessed by two disinterested, independent witnesses. Now, interestingly, in the District of Columbia, oral wills also are not valid with the exception of very limited circumstances. And according to their code, and for those of you taking notes, it's the code 18-107, an oral will isn't valid in the District of Columbia except that a person who is in active military or naval service, or a mariner at sea, may dispose of their personal property by word of mouth if um, the oral declaration of the property or disposition of the property can be proved by two witnesses who were present at the time of that declaration, and were requested by the testator to bear witness that this was his or her last will, and the will was made during the time of their last illness before they died. And three, that the will is eventually reduced to writing within 10 days after it was made. So that's for those of you in DC, and I'm referring to the DC code right now. But I mean, for the most part, just know that you need to put it in writing. I mean, if you really want to secure, for the vast majority of us, if you want to secure, your interest and make sure that your plans will be executed according to your wishes, document it and put it in writing. Number 3, all my property will be dispersed by the terms of my will. Now, a will, keep in mind that a last will and testament only distributes the assets left in the decedent's individual name. There are assets also that pass by maybe title or beneficiary designation, and those pass outside of the will by operation of law. So, your home, retirement accounts, and life insurance policies are examples of these types of assets that pass outside of the will. Now, that's why, you have to be careful with these DIY software programs, and they'll create some cookie cutter template and you just list stuff on there, but those assets may not be properly coordinated with other aspects of your estate. And in a lot of aspects, the titling of assets and beneficiary designations are just as important as the will itself. So keep that in mind. Number 4, I'm too young for estate planning. Now, in my opinion, all adults should plan for incapacity or death, regardless of the value of your estate. And again, just as a reminder, your estate is everything that you own, it's all your stuff. And not doing so, not having that plan, often ends up really in a mess for those who are left behind. Accidents are just that, they're not planned, right? And illnesses are never planned and can happen at any time. So everyone should have, a nominated legal representative, someone you've chosen to handle your financial and medical care decisions in the event that you are incapacitated, whether that be for a week, a month, 6 months, however long it is. In addition, um, not having a valid will or a trust identifying who that representative for the estate will be is going to end up in increased costs for your estate overall, as well as causing confusion and chaos regarding who receives what in your estate, and you really, really don't want that to happen. Let me pause here before I go to the next one. Let me know in the chat if any of these myths, if you've heard of any of them, if there anybody in your circle of friends or even in your family that has ever, you've heard them say one of these myths before. I bet you have. So let me know. Let me know in the chat. We're going to move right along. Number 5, the 5th myth. Oh, I just need a simple will. And I hear this quite often when people are first reaching out to us because, quite frankly, they're not sure what they need, but they think they just need a quote unquote simple will. Most people, approach estate planning with the opinion that their needs are simple, they're uncomplicated. In reality, most people have estate planning needs that are more complex than they realize. For instance, many people name children or grandchildren as beneficiaries of their estate. Now, in doing so, it's important to think about when the estate should be distributed to that particular beneficiary, at what age, at what intervals, right? How much, should be distributed to them. And what if, the beneficiary dies? Then what happens to what you've designated for them? How is that to be distributed? There are other estate planning considerations that require more thought and involve a lot more planning for, say, the guardianship of minor children. You have to think about estate taxes. If are there, children with special needs in your family? So that present. Oh, and of course, blended families as well. That's something that comes up quite often. So there are all these considerations that a cookie cutter plan may not and usually does not take into account. Number 6. A durable power of attorney gives my chosen person authority to take control of and administer my estate. Oh my. Listen, a durable power of attorney is a great tool that allows another person or several people to legally conduct certain business for you as the principal. Now, the terms can be modified to allow that authorized person to act immediately or only act in the case of your incapacity. However, know that the power of attorney ends with the maker's death, as well as all powers granted in the power of attorney. So they expire. So once you die, the power of attorney is no longer in effect. Okay. And the control over the estate and any accounts is going to transfer to a person that is who's appointed by the court during a probate process, or a trustee if if you created a trust. But no, the power of attorney ends when you die. So please know that. Number 7. Having a revocable trust avoids probate. Now, there are those of you who wish, people who wish to avoid, the public process of, going through probate. And a lot of folks use a revocable living trust as a, dispositive tool in their estate plan. But a revocable trust must be funded properly in order to avoid probate. So the assets in the estate, either, they've got to be titled in the name of the trust or payable to the trust by a beneficiary designation. But all those things have to be, all aspects of your estate plan need to be in sync. And if your goal is to avoid the probate process. Number 8. Here's one. When I give my daughter access to my bank account, she can only use the money to pay for my medical expenses. Okay, listen, that's what you hope is going to happen. And, if they're really a responsible person, that's what will happen. But legally, folks, she has the right to use the money for any purpose if she's the owner on the account. Let me say that again. Legally, if she has the right to use the money for any purpose. A week in Cancun, a shopping spree, insert what you will into that blank. If she's the owner of the account, she can blow right through it, okay, and legally. So bear that in mind when you try to be uh you know um I don't know, crafty and say, well, I'm not going to have an estate plan. I'm just going to, put so and so as a joint owner on my account. Beware, because the day that you do that, they can wipe you out. So there are other options, there are other ways that you can have your bills paid. And working with an estate planning attorney can help you craft a plan that's really going to protect you and really identify people who are best suited to serve in these responsible positions, in these positions of trust throughout your estate plan. Number 9, I don't need to worry about incapacity until I'm a lot older, until I'm much older. In an ideal world, that statement would be true. But I mean, come on, the last couple of years, I should say, should prove to us that we never know when an accident, injury, or illness is going to strike. Creating legal documents that plan for incapacity is an important safety measure in your estate plan. And having incapacity documents in place means that your loved ones will have the power and the tools that they need to care for you if needed. And then number 10, I did my estate plan a few years ago, so I don't need to think about it anymore. It's often said that estate planning is a process. It's not a one and done. It never is. Why? Because change in your family circumstances, your marital status, your health, economic status, and other maybe changes in the law often require a revision to your estate planning documents. And planning documents that say are more than like 5 or 10 years old often require a revision. At a minimum, you should, lay eyes on your documents every couple of years. Most often, revising an estate plan or simply making an edit, like I said, simply involves making minor changes to those documents, but those changes are important. In addition, it's important to confirm that the planning that has been done by you is complete. So sometimes, final drafts of documents remain unsigned, or the signed documents lack, the coordination with other assets in your estate. I mentioned earlier about coordinating beneficiary designations in assets that pass outside of the will with whatever you indicate your beneficiaries in the will. And that's done through proper titling and proper identification in your beneficiary designations. So we debunked 10 myths about estate planning today. Let's all recognize that some of the myths we believe are meant to keep us in our comfort zones. I want you to ask yourself, have I allowed these myths to stop me from creating an estate plan? There's a saying that once you know better, you ought to do better. And today, I want you to commit to doing better today for yourself and those you love. I want you to go to my website at Elsa W. Smith Law for free resources to help you get started. I want to thank you for tuning in to this episode of Women Winning Wednesdays. If you need assistance with estate planning matters in Maryland or the District of Columbia, let's have a strategy session. Reach out to us. We are here to help. I'm Elsa W. Smith, your Maryland estate planning attorney, empowering women through estate planning. Thanks for watching, and I'll see you in our next episode. Take care.